Hi, good morning, everyone. My name's Judge Adrian Young. You can see on the screen, Judge Mariani is with us virtually. And then to my left, Judge Bazzi. As was discussed in the intro, I'm only presiding judge for this first case. And you hear, I recognize most of you. You know that in cases involving minors, we're not to use their names. This first case where I'm presiding is one of those cases. So be thoughtful as the case is being argued. And after this first case, we will briefly recess and then come back out, and you'll hear from presiding Judge Korobkin the usual kind of intro speech, and we'll hear the rest of case call then. So I'm going to go ahead and call just this first case where Judge Mariani is joining us. Thank you, Judge Mariani, for jumping in. And I'm now calling case number 15. That's court number 377155. And it's in Ray A.A. Hill Price Minor. And it looks like we have one person, or no, two people for argument. And Ms. Steele is here remotely.
Good morning, Your Honors. And I do believe that my client should be logged in as well, just so the panel knows that she's here.
Thank you for telling us.
Sure. And I think Mr. Parnes is endorsed for argument as well. I'm not sure if he's in person.
Present in the courtroom.
Okay.
That was my mistake.
Perfect.
Thank you.
Thank you.
Yeah. You may proceed.
Thank you very much, Your Honor. And thank you all for allowing me to appear by Zoom. I appreciate it. And I know the panel has read my briefs and is well versed on the arguments. I did just want to highlight a few of the more pertinent arguments on my client's behalf. It is our contention that throughout this case, Mother made continued efforts to address the issues that brought the case into care, including housing, employment, and her mental health issues. It's very important to note that she was making very significant progress, to the extent that at one point in July of 2022, the trial court was considering returning home. She had unsupervised visits. Everything was going very well. She was receiving glowing reports from the workers. The trial court was praising her efforts. She was doing exceptionally well, more so than we see in a lot of child protection cases. Visits with her son were going well. She had housing, she had employment. She did hit a bump in the road after that, unfortunately. And then in October of 2022, DHHS was considering filing a petition to terminate her parental rights. That's 3 months after this incredible period of success that she had, which is really not a sufficient amount of time to allow her to continue to make progress with her treatment plan. The agency did not provide reasonable efforts with respect to the services that were offered to her. For a lot of it, she was left on her own to find her own mental health treatment. And she did work as a mental health professional for a number of years, and that was argued in my brief. And so fortunately, she was able to locate these services on her own behalf, but that really should not have been incumbent upon her. That is incumbent upon the agency, specifically with respect to making those reasonable efforts to support reunification between her and her son. She unfortunately had her parenting time suspended in October of 2022. Mother's trial counsel did correctly argue that if her visits were suspended, that issue would subsequently be used as a basis to terminate her parental rights, because it would damage the bond between her and her son. And that is exactly what happened. She wasn't even permitted at some point to visit with him virtually. And I would argue that there were insufficient findings made on the record that if virtual visits were held, there would be some risk of harm to the child. So it is our contention that these errors do require reversal. My client would request that her parenting time be immediately reinstated. She also has a number of concerns about her detainment in mental health facilities and how that impacted the court's view of her and her treatment within the child protection proceedings. And finally, I do understand that this is not a customary request, but my client has inquired as to whether or not she would be permitted to address the court directly. I told her that I would make that request on her behalf. She has been a very zealous advocate on her own behalf throughout the trial court proceedings and these proceedings. So I indicated to her I would ask the panel to see if that would be possible. But other than that, if the panel has any questions for me, I'm happy to answer them.
Thank you. I'll address your client first. Thank you for advocating on your own behalf and doing so today through your counsel as is appropriate in the court. We won't hear directly from your client, Ms. Steele, but thank you again for asking on her behalf, and congratulations to her for being such a zealous advocate on her own part. I do have a question for you. So
Sure.
I can see that trajectory you described of mom. But it feels almost like you are requesting that once there's a good stretch, that the clock kind of restarts for the 186 day number. It's almost like you want us to ignore what happened at first because there's this window in the middle of positive behavior. And I'm not convinced that we can do that under the law.
Thank you, Your Honor. I think that's a good question. And I'm not asking the court to ignore the trajectory of the case and what happened and what brought the case into care. I'm just asking the court to focus on the fact that because mother had such a sustained period of successful compliance, that speaks to her ability to comply with the parent agency agreement. Because in a lot of cases, we have parents that for whatever reason can't or won't comply. And in this case, she did prove for a very long period of time that she is capable. And as we know with mental health issues, it's sometimes there are periods of success and then there's a little bit of a backslide and then there's more success. So I'm just asking the court to consider giving her additional time to prove that she can continue to comply with the parent agency agreement.
Any questions, Judge Mariani? Any questions? Okay. We're going to hear from Mr. Parnes, and then you have some time for rebuttal.
Thank you, Your Honor.
May it please this honorable court, Elliot Parnes, lawyer, guardian ad litem for the minor child. I have just a few points I'd like to emphasize. Appellant's primary argument is that the department or the agency did not provide sufficient services for the appellant. I think the facts clearly indicate that that's not true. They clearly provided services for this mother. They referred her to mental health services. They referred her to parenting classes for at least 3 times. She was referred for individual therapy. She was provided visitation specialist. It was appellant who chose not to take her prescribed medications. It was appellant who clearly did not take advantage and benefit from the many services provided to her over the 4 years. In re Gazella indicates the appellant may participate in services, but she also has to benefit. And it is my position as the attorney for the minor child that she didn't benefit, and that a statutory ground MCL 712A.19B sub 3 sub J, that there was be reasonable expectation that the minor child would be harmed if returned to her. Fellow counsel indicated that she had unsupervised visits, but the unsupervised visits didn't go well. There was the incident where she made the minor child run sprints in the middle of the night at 1 o'clock for no reason. He was out there running sprints. She never provided proof of any work in the mental health environment. I asked her in cross-examination, do you have a license? Do you have any proof that you are employed as a mental health provider? And she didn't have any. Second, in the case of In re Smith Taylor cited in the brief, this court indicated respondent's failure to significantly address her mental health, or erratic behavior through the proceedings and her failure to acknowledge the severity of her mental illness demonstrated that she did not have the ability to properly care for the children and that it was in the best interest for the children that her rights be terminated. This present case is almost on all fours with Smith-Taylor. Appellant in this case failed to significantly address her mental health, her interruptions during the proceedings, in which I, in my brief, put in footnotes how many times she was required to leave the courtroom because of her disruptive behavior. Her failure to acknowledge the severity of her mental illness demonstrated that she does not have the ability to properly care for this minor child. I must say, through my 47 years of practice, I would say that this appellant had the most mental health illness problems that I've ever come across in representing a child. Based upon all of the best interest factors cited in my brief, I believe that the petitioner provided proof not only by a preponderance of the evidence, but I believe by clear and convincing evidence that it was in my client's best interest that the mother's rights be terminated so that he can obtain the permanence and stability that he deserves and needs. Therefore, I'd ask this court to affirm the order of terminating the parental rights of appellant.
Mr. Parnes, you mentioned this being one of the more severe cases in your decades of experience. I'm curious how severe mental health intersects with the and I'm blanking on the case, but you'll know it. Where individuals with special needs have basically the resources allocated to them need to recognize that and almost be individualized to that specific need. How do we balance those two realities, especially with what Ms. Steele said about her kind of having to find some mental health resources on her own?
Well, I know what you're citing, the case of Hill,
Yes.
Albertan, where
Yeah.
if a parent is identified as having special needs, the department is required to provide special assistance. That was never raised here by the mother or any of her attorneys. And as the court reading all the transcripts, we ended up on the fourth attorney. Why? Because the other attorneys requested to be released. And I don't believe that any of the service, she did get special services. She got mental health services over and above what most parents receive. And she was giving more time than most parents receive. This is a 2021 case. We're now in 2026. This is 5 years. This is beyond what we normally see in these kinds of cases. And I believe that she had the opportunity to participate in mental health services. She just didn't do it, and she didn't benefit from any of the services that she did take.
Judge Mariani, any questions? Okay. Thank you.
Thank you, Your Honor.
Any rebuttal?
Just very briefly, Your Honor, I would just address the argument that she didn't benefit from any of her mental health services. I would respectfully disagree with that because of what I previously argued with respect to her successful compliance, to the extent that the trial court was actually considering a return home. She sought out a lot of the services on her own behalf, and she voluntarily was hospitalized. Some of her hospitalizations were not involuntary, they were voluntary. So I would submit to this court that definitely signifies compliance with mental health treatment. And of course, there were some setbacks along the way, but she never stopped trying during the entire case to comply with services. Of course, her mental health issues made it difficult, but through her actions, not just her words, she continued to try to make efforts to improve herself throughout this case.
Okay. Thank you very much, counselors.
you.
This case will be submitted.
Thank you, Your Honors.
We're going to take a brief recess and then kind of reshuffle everybody. Okay.
All right.
Good morning. Welcome once again to the Michigan Court of Appeals. Thank you very much to my colleagues and Judge Mariani and all of you for accommodating a quick substitution. So this is the first day of case call for panel number 1 of the court's April 2026 session. My name is Dan Korotkin, and I'm joined here today by Judges Adrian Young and Miriam Bazzi. Quick couple of comments before we get started. First, we understand these cases are very important to the litigants and to counsel. I want to assure you they are important to us as well. We have been diligently working on these matters. We've had the benefit of your briefing, as well as the work of our excellent research division and chamber staff. We're familiar with the relevant facts, the pertinent law, and so we ask that you try to focus your oral argument today on your most important points, why you should prevail, and what is most critical for us to understand. Finally, as I think Judge Young mentioned previously, but just a reminder, we're hearing matters involving sexual assault victims, personal protection orders, and children. And because these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in these cases. So with that, we very much look forward to hearing your arguments, and we will resume by calling case number 1, docket number 376042, In re Vincent Minor. And I believe we have one attorney here who's endorsed for oral argument. No one's checked in. Okay, so that case will be submitted on the briefs, and we will move on to item number 2, docket number 370579, People versus Kenshawn Devon Littleton. And Mr. Simon, welcome. Good to see you, and whenever you're ready.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Littlejohn. The people agree as to argument 4 that the CCW should run concurrent with felony firearm. However, that does absolutely nothing to reduce Mr. Littlejohn's exposure. That would require only ministerial correction to the judgment of sentence.
That was one of my questions. It's not a full resentencing. It's just tell the trial court fix this, and then they reissue a new JOS, right? Okay.
My concern is argument 3. That would be the Lafler versus Cooper issue. Mr. Littlejohn stated at sentencing that he had been unaware of the video. He had not seen it. His lawyer had not showed it to him. Had he seen it, had he been able to review it, he would have been in a better position to evaluate the plea offer of second-degree murder. And I believe it involved a 25-year mandatory, not mandatory, but a 25-year minimum sentence. He says that he was never made aware of this information. He was not able to fully appreciate the value of the offer. But had he seen it, had he known of it, had he reviewed it, he would have accepted that offer.
Question. So in the Detroit police officers investigators report, don't they have a summary of the contents of that video?
I'm not sure in this case whether or not that was the case, but the fact is that video is, well, it's video. You can see what actually happened as opposed to relying on the subjective interpretations of an officer in a very brief recitation of facts used in support of obtaining a warrant. And if he did see that, I don't know how impressive that would have been upon his decision based upon an adversarial opinion as to what the video entailed. I think that this court should remand the matter to the Wayne Circuit Court for an evidentiary hearing pursuant to Lafler versus Cooper. I think we need to hear from Mr. Littlejohn, and perhaps also from his attorney, I think Mr. Cooper, because it is, I think, strictly on all fours with Lafler versus Cooper. I think that he was unable to fully and effectively evaluate the offer, says he would have accepted the offer, but for this failure of his counsel to provide him with the necessary tools to make that decision. And we believe that that a remand would be appropriate under these circumstances.
So is your thought that all discovery should be provided in order for a decision on a plea to be, or plea offer to be knowing?
Yes, I mean, I know that he can't receive a copy of video in the jail,
Right.
but his attorney can come in with a laptop with loaded with the video and show him he is entitled to see that. And I think that he should have seen it. And he says he didn't see it, and we have nothing from Mr. Cooper to say that he did. So I think this is a serious question that the court needs to evaluate before deciding. And if the court perhaps might retain jurisdiction, send it back, have a hearing, and then revisit the issue, I think in the interest of justice, that may be an appropriate move.
Specifically in the video, is he indicated would have changed his mind? I mean, the video ultimately is a interview of the witness, and the Detroit Police Investigators Report indicates what that witness and this is the investigative report, which is also located in the PSIR, and he hasn't indicated he never received a copy of the Detroit Police Officer Report. So we have a recitation of what that witness indicates he observed being given in discovery, and then we have he's saying, but if I would have seen the actual video, it would have changed my mind about the plea. So what was it about the video itself that he wasn't aware of that would have made him change his mind?
I don't think this was a video of the interrogation or the interviews. I think this was video of what happened inside the store. From his perspective, while he was at the store, I think he believed he was acting in self-defense. And I think that he believed that that defense would prevail. Not having seen the video and perhaps maybe his subjective recollection of the facts may have differed from what he was able to see if he had been able to see it, and perhaps seeing what would be shown to the jury, seeing what the prosecutor would be presenting, I think might have influenced his decision, because he is there looking at it from his perspective.
Counselor, may I interrupt you? Wasn't the video shown at the preliminary exam of what happened in the store? And in fact, didn't the magistrate review that, and wasn't that part of the bind over decision?
Some video, not all parts of it, but there was more. There was certainly a lot more video. There were several different cameras. There were several different aspects. And I think that he says he wasn't able to fully evaluate that information. And I think that this court should further explore that allegation.
Anything further? Okay, thank you very much. That matter will be submitted. Stay right there, Mr. Simon. Our next case is item number 3, docket number 374631, People versus Timothy Demetrius Holden Jr. Both sides are endorsed for oral argument, and I believe Mr. Badcock is appearing remotely. Mr. Babcock, can you hear us okay?
I can, Your Honor.
Okay, Mr. Simon, whenever you're ready.
Thank you, Your Honor, and good morning. May it please the court again, Jonathan Simon, this time on behalf of Mr. Holden. Mr. Holden was found guilty of second-degree murder. involving a shooting which took place in his apartment by a man who was considerably intoxicated, blew .212, who had called, made threats, who had was armed with a gun, and he came in. He put the gun down on a ledge, but he kept on going back toward it. He kept making threats. This is inside the apartment of my client.
Great. You
Certainly,
said he kept making threats. I don't recall that in the video.
well, these were phone calls that were exchanged prior to the complainant, the victim, arriving at the scene. I don't know that any of that was involved in the video, but I think the video clearly shows also that the complainant was pacing around, was intoxicated, was kept approaching that area where the gun was located, and my client became, I think, reasonably apprehensive of an immediate battery, and being in his house with no duty to retreat, he responded under what he thought, reasonably believed to be a situation involving self-defense. There was a motion for a new trial, so we're asking the court to view this from two different perspectives, one involving the sufficiency of the evidence, and one involving whether the result was against the great weight of the evidence. Obviously, if the court feels that the evidence was insufficient, that would result in vacation of the charges. If it's against the great weight, of course, then the remedy would be to for a new trial.
If anyone comes into your home armed, you can, it seems like it seems like the version of self-defense you're advocating for is that at any point in time, if you have an armed person in your home, you can shoot them. Because there was nothing on the video or in the testimony to indicate that Mr. Holden, for example, asked this person to leave. And there was no question that he was armed. To your point, the decedent comes up, takes out his gun, sets it down in plain sight, and just judging by the bits and pieces of the audio of the earlier phone call that led to him coming over, there's no question that he was coming over and somebody was agitated or both people were agitated. So I don't know what to do with the fact that, like, yes, Mr. Holden's in his home, but somebody came in armed. He didn't ask them to leave. The armed person set down their gun, and throughout the duration of their confrontation was gesturing about a physical fight. And that's also where I think the drunkenness kind of hurts Mr. Holden, because the physical confrontation was sloppy and reads as very unserious, probably because of the level of intoxication of the decedent. And so what do we do with the fact that there's no get out of my house? There's no question that this person's armed and you just let them come in and set their gun down on your banister?
Well, he did not arrive alone. He had two people with him. So there's actually three people who come to the house. I don't know that there was any evidence that the other two were armed or had any beef with Mr. Holden or had threatened Mr. Holden, but certainly they're there and perceived as backup to the complainant. We don't know how that may have impacted Mr. Holden's reasonable apprehensions. Certainly, though, when he's walking around, he's heading toward that gun, and all he needs to do is pick it up and shoot, I think, and Mr. Holden acted reasonably in preemptively shooting the complainant. I don't know that it's really necessary to say, get out of my house, when you have two backups and there's three people there to in a combative situation. The totality of circumstances, we respectfully submit that this matter should either result in a vacation of the conviction or at a minimum a remand for a new trial.
Okay. Thank you. You'll have time for rebuttal, of course. Mr. Babcock?
Yes, Your Honor. Russell Babcock on behalf of the people, and I'll be very brief, Your Honors. I mean, we've heard defense counsel's a recitation of the defendant's view of the facts, but the reality was and is that this court is required to view the evidence in the light most favorable to the prosecution in this case. And in fact, as the court is well aware, it is the trier of facts role, the jury in this case, to judge the credibility and weigh the evidence, all this evidence was submitted to the jury, both in the form of video footage as well as testimony from multiple witnesses. So, Your Honor, that is the burden that the defense faces on appeal. And quite frankly, we believe that the trial court reached the right result. And we are asking, and we're going to rest on our brief, and I'll answer any questions the court may have. We'd ask that the court basically affirm the lower court's rulings.
What do you view as the difference between the insufficiency standard and the great weight of the evidence standard in terms of how we ought to view this case? Because, you know, I mean, look, I certainly respect the jury's verdict here, and if maybe we would have decided something differently, then that's not the standard for insufficiency. But it seems like there's still a little bit of room for us to evaluate the evidence when it comes to the great weight of the evidence standard.
Your Honor, that's a good question, and off the cuff, I think the way I would view it is you have to show that the great weight of the evidence was against the verdict that occurred here, which I think is even a higher standard, I would think, than the insufficient evidence, which is the standard that I just mentioned to the court a few minutes ago. Now, I will acknowledge I'm doing this off the cuff, but I think that whether you look at it from the insufficient of the evidence or even the great weight of the evidence, both of the evidence of this case was more than sufficient under either standard to survive and sustain the verdict that was properly reached by the trier of fact in this case. And again, I think under either standard, you're supposed to give deferential treatment to the trier of fact's unique perspective. They were able to assess the witnesses. They were able to look at the exhibits, the evidence. Whereas this court, of course, doesn't have that full ability because obviously the witnesses are not being called before the court. The exhibits, other than what's been submitted to the court through our filings, that's what the court is limited to. So I think under either standard, and again, I will acknowledge what I just said a moment ago about the great weight of evidence is based on my off-the-cuff thoughts. I think that under either standard, I can't imagine a situation where this court could find that the great weight of the evidence was against this verdict or that there was insufficient evidence for this verdict. So we'd ask that the court affirm the trial court's rulings.
Mr. Fine.
Well, certainly under Lemon, this court or the trial court cannot be the 13th juror. We don't expect the court to substitute its opinion for that of the 12 people who decided this case. But I would submit that great weight is a lower standard. I mean, I think I learned in law school, maybe it's been a while, but I believe that beyond a reasonable doubt, I was always taught was the highest standard that there is. The fact is that it would result in a greater relief because it would vacate the conviction entirely. The great weight of the evidence standard would only result in a new trial, which would, of course, provide lesser relief. So to answer the court's question to Mr. Babcock, I would submit that the great weight standard is lower than the proof beyond a reasonable doubt standard.
And how does that apply here? I'm just trying to piece through in my mind. Because it was proper to instruct the jury both on self-defense and manslaughter for that matter. And the jury chose to reject those options. So trying to figure out if there's what is the space for us between insufficient evidence and great weight of the evidence? Because we all watched the video and, it's an unusual situation to say the least.
Oh, that's a very good question. I don't recall seeing very many cases where convictions have been overturned on the great weight issue. And but I would submit that it's clearly a lesser standard, and the court should make that consideration when evaluating these issues.
Okay, thank you very much. That case will be submitted, and we thank you for your arguments here. So moving on to item number 4 on our docket is docket number 372505, Right Way Rehab versus Auto Club Group Insurance Company. Mr. Saylor here. Right, Mr. Kassoon, is that right? Oh, I'm sorry. Thank you very much. All right, Mr. Saylor.
Good morning, Your Honors. May it please the court. Daniel Saylor appearing on behalf of the defendant appellant Auto Club. Your Honors, this case, of course, is a no-fault issue regarding the no-fault fee schedule, so-called, and the briefs focused in on the legal issue at the center of the controversy. And since the briefs were filed, the court issued a published opinion in Favo versus Member Select. Judge Kropkin, you will probably remember that. It's on application of the Supreme Court now, but as it stands now, that case is on all fours with the legal issues presented in this case, whether the multi-procedure payment reduction rule and the bundled code, so-called package service rules, may be used and applied for under the Medicare definition to determine the no-fault fee caps. And contrary to the arguments that had been raised by the plaintiffs in this case and in many other such provider cases like this, the court rejected the notion that those rules are automatically unrelated and can't be used. And in fact, the court specifically held that both of those rules that are at issue in this case are related to the rates and amount payable by Medicare, and therefore by legislative fiat should be taken into consideration to determine the no-fault fee cap. I would save any time I need for rebuttal unless the court has questions before I ask the court to reverse the denial of the partial summary disposition motion in the lower court and remand it to determine whether the amount already paid is the exact correct amount or if it needs any adjustment.
So the MMPR?
PPR.
Right. That was literally in the Favit case, as I understand it. The bundled code was not, I don't think, like actually in the Favit case. So do you want to say anything about why bundled code fits in with all of the others that have already been?
Well, certainly, substantively, it too is directly related to the rates in the fee schedule. It's a rule that specifically says for this particular code and the corresponding rate in the fee schedule, if it's an a la carte situation, yes, there's an amount payable for that particular procedure or service. But when it is part of an overall procedure and not a la carte, Medicare applies a different code and therefore a different fee schedule rate. So it's not like it's not paid by Medicare. It is paid, but it's paid as a packaged deal. And I believe that Favo did address that specifically. The court's opinion first uses the statutory examples of 5 limitations that are obviously unrelated to the rates in the fee schedule. And following that discussion, the court said, but there are limitations and reductions that are related to the rates and amount payable by Medicare. Relevant here, the MPPR rule provides blah, blah, blah. And that says similarly, under the package service rule, there are various services under which they're packaged into the payment for a covered surgical procedure. So
you're saying package service and bundled code are
they're referring to the
similar
same
enough
thing.
to I'm sorry, say
I
again.
think they're referring to the same thing. A package service is one where the service is paid in conjunction with all 3 or 4 combined services into one overall procedure with its own fee schedule rate, as opposed to if you went in and just had this particular, I don't know, like an injection or something that would have its own a la carte rate. But when it's part of an overall procedure, then it's paid under the other rate. So I think they're referring to the same thing. Thank you, Your Honors.
Thank you, Mr. Salem. Morning.
Morning. May it please the court, since briefing, of course, as brother counsel has correctly indicated, FEBO has resolved the underlying legal question. We concede that point, and under FEBO, Medicare limitations related to the fee schedule may be considered under 3157. But that does not resolve the motion that Auto Club actually filed below. Auto Club did not seek only statutory clarification. In the underlying motion for summary disposition, Auto Club asked the circuit court to rule that the providers here were not eligible for anything beyond the amounts already paid, that no additional expenses had been incurred, and that the disputed bills should be dismissed under C10. That requested relief turns on application, not merely on legal availability of Medicare rules and rates. So our position here is narrow. We're not asking this court to revisit FEBO. We're only saying that FEBO does not automatically entitle Auto Club to dismissal of disputed bills on summary disposition. Auto Club's own reconsideration motion confirms that posture. And after the trial court denied summary disposition because it saw factual issues, Auto Club argued the court erred by treating the matter as factual and insisted that the issues were legal. Even after FEBO, the question in this appeal is whether Auto Club is entitled as a matter of law to the broader relief it sought below, and it simply is not.
And so you want a remand to sort of apply FEBO to the facts of this case. Is that?
I think that applying FEBO to the facts of this case gets you to the same result. The underlying court, what made their decision pre-FEBO, but even post-FEBO would have ended up in the same position, which is denying the motion for summary disposition because their motion for summary disposition asked that all bills be dismissed.
So I'm looking at my understanding is that the defendant filed a motion for partial summary disposition. And I guess I was interpreting that to mean we want the FABO. I mean, it was pre-FEBO. We want what became the FABO issue, the legal issue, decided on summary disposition, and then the reason why it's partial is because you then need to figure out whether the calculations and reimbursements are actually correct. Am I misunderstanding what that was?
Well, I think so. My understanding of their underlying motion for summary disposition was them taking the position that they had already paid the amounts that they were required to pay. They chose a certain specified amount based on their calculations. They paid it voluntarily. And their argument at SD was, we paid everything we needed to pay. There's nothing else outstanding. And therefore, everything else should be dismissed, which would in effect leave no issues pending before the court.
So you want a remand with the opportunity to discuss whether defendant paid the correct amount of PIP benefits?
Yes.
Okay. If there's nothing further, we'll hear from Mr. Saylor if you have any rebuttal. Thank you.
No, I don't have a rebuttal. I just want, in case there's any, I would second the notion that it was partial summary disposition only because the two parties were separate from application of these limiting rules. They were plaintiffs disputing that the amount we paid was proper. We believe that it was correct. We think that when it goes back down, it should be found that what is owed has been paid. There's factual disagreement on that. We acknowledge that in our appellant's brief. But as long as it goes back down, so now the legal landscape is clear. We're just looking at how much was paid was it exactly in conformity with application of these rules and what they submitted? So so I concur. I think that we're on the same page as to what that remand should look like.
Thank you. Thank you both. Have a good day. That case will be submitted. Moving along to item number 5, docket number 375574, People versus Tara Lee Luna. Oh, thank you very much. Okay, so we have that consolidated with docket number 375575, also People versus Tara Lee Luna. And I believe we have Mr. Ferrone endorsed for argument remotely.
You do, Your Honor. Thank you for letting me appear via Zoom.
Hold on, Mr. Ferrone. Hold on just a second. Okay. Okay.
Okay.
Mr. Ferrone, I think you're on your own here, so whenever you're ready.
Thank you, Your Honor. Michael Ferrone on behalf of Ms. Luna. Thank you for letting me appear via Zoom. I tend to stand on the written brief. However, I thought it was important to appear today because of this unusual. I haven't been in this situation before where I'm not certain the entire pre-sentence report is in front of the court. Though maybe the court has questions about that. The court's record clerk did write to me and inquired about that, and I did write back. I filed my response via the court's true filing system. I included the email that I sent the MDOC in 2025, the letter I wrote the field agent, and talked about communications with trial counsel. So I think there's part of the report missing by Ms. Reiniger, but I'm not sure what to do about that. Ms. Luna does have a 36-month minimum as a departure, but it's I say only a 36-month minimum. She had a lot of jail credits, so I had to get the appeal off the ground if we were going to do an appeal, and she did want to. So that's where we are. Just appearing in case the court has any questions of me. Otherwise, I would stand on the brief.
I don't have any questions.
I don't have any questions.
All right, we're all set then. Thank you very much, Mr. Ferrone. That case will be submitted. We appreciate you appearing today.
Thank you.
Okay, moving on to item number 6, docket number 370804, Johnny Zaytona versus John Leonovich. And I apologize if I'm mispronouncing that. I'm sure I'd like you to correct me if I am. Leonovich. Yes, great. Welcome, and you're both endorsed for oral argument, and Mr. Iyer, whenever you're ready.
Thank you, Your Honor. May it please the court, Jason Long.
Oh, I'm sorry, Mr. Long.
No apologies necessary, Your Honor. Jason Long on behalf of the plaintiffs and appellants, Johnny and Nancy Zaytona. I just want to reserve 5 minutes of my time for rebuttal. Hopefully it won't be an issue.
Yeah, so we ask you to keep your own time, but that's fine.
Thank you, Your Honor. Not a lot of dispute that being recorded with cameras is kind of a fact of life now. Doorbell cameras, security cameras, the cameras in the case that someone else argued to Your Honors this morning. The issue here is whether there are places that provide a respite for that. And we'd submit to Your Honors that the home and its surrounds are such a place. There's we think, a long history of law, cases from the U.S. Supreme Court referring to your home as your castle, cases from Michigan saying your home gets special consideration. We'd submit that the defendants crossed the line from things they can do to secure their own home into things that were surveilling my client's home. And just there's a lot of things we could talk about, Your Honor, but I want to try to be brief. A couple of highlights of the case and of course, to answer Your Honor's questions. The home and its surrounds are a private subject matter. The intent here, I think, was clear, and the use of technology was clear and bolstered the intent. First point, and a claim for intrusion upon seclusion is that something has to be a private subject matter. And the trial court's conclusion was that the Zaytona's backyard couldn't be a private subject matter because it was on a lake. And I think one of the real dangers of the trial court's reasoning was that it equated visibility with subjection to recording with high power equipment. And it said, well, the people on the lake, people across the lake can see you. That's a lot different. And I'd submit to you, it's different in kind than having high-powered cameras trained on you, recording you all the time. Anytime there's motion, as the consultant put it, when the wind blows, when the clouds move, when the dogs run by. And I would add to that, it's important in Michigan as well, the way this court applies this to a lakefront property. In Michigan, we have thousands of lakes, thousands more homes on those lakes. And those are some of the most desirable properties in the state. It's only last week that this court issued a published decision, easy for me to say, in which Judge Yates referred to waterfront properties as commanding, quote, a king's ransom. And I think it would be a pretty big blow to the state if there were a rule in the state that said, if you have a property that fronts a lake, you have no reasonable expectation of privacy when you're behind your home, between your house and the lake. If your home and your yard, your backyard, behind your home are in a private place, I'm not sure what's left where you're not subject to recording. Second is intent. I want to talk about briefly. I think this is an easy one for the court because Mrs. Leonowitz said, our cameras did what they did because I wanted to see the Zaytonas yard. And it's in our materials, but this is the view from one of those cameras. And it shows practically nothing but the Zaytonas backyard. So you can go on about, well, we wanted security and things like that. A property or a camera, excuse me, aimed at someone else's property isn't doing much to secure your own property. It's there to provide surveillance, to record activity.
So you just presented the court with an image captured by one of the cameras, but my understanding was that discovery was not complete in terms of the capability of all the cameras and everything that they've produced. Is that?
That's accurate, Judge Young.
Okay.
There was a prior case between the parties where there was some discovery. There was
And in
more,
this case, no discovery yet.
no discovery,
Okay.
none whatsoever. And just to add context on that, we filed our complaint. The defendants filed a motion to dismiss. Judge Grant granted that motion.
Do you think we have to, I guess in my mind, and I think the briefs reflect this, there are kind of two potential categories of invasion of privacy here. One is the picture that you just showed us, and the other is the possibility that the cameras could see inside the home. One strikes me as a more severe situation. The latter strikes me as a little bit more severe, although I understand your position about the former too. Do you think we need to reach the question of whether your lakeside beach is private from your neighbor, if in fact we also have a possibility that these cameras could see inside the home, which is a more serious situation?
I agree with you that it's more serious, Judge Karopkin. I think, and I guess either of those I would submit is a sufficient basis for the court to say that the trial court made a mistake here. And because we had, a couple of experts who looked at the stuff, analyzed what was there and said, there's a camera aimed right at this window into the house and it can see through. We didn't get to look at everything. And if the court wanted to stop there, I think that would be enough. If the court looked at it the other way and said, these cameras are aimed at the Zaytona's backyard, that's also enough. So would you need both? I think the answer to that is probably no. A quick word about the technology. Technology's everywhere. Technology doesn't, I think, drive what the court has to do, but I think that the technology, I think it illustrates the intent. There's a big difference between a camera that points out and doesn't record 24/7, when the dog runs by, the clouds move, et cetera. But that's what we have here. The technology illustrates whether it's there to detect threats to your own property or to capture images of somebody else's property. So with that, unless your honors have questions, we request that the court reverse the trial court's decision, send it back for further discovery. And I guess I would just say that we think the defendants crossed the line. Your honors don't have to agree with us about that in order to reverse. You just have to agree that there's got to be more that has to happen before that decision is made.
Can I ask one before you,
Of course.
before you leave? There was an intentional infliction of emotional distress claim. Was that supposed to be applicable to everything or just the cameras viewing the inside of the home?
It was
situation?
everything, Your Honor. It wasn't as discreet as just that. Our position was that the 16 cameras, 7 of which were acknowledged to be pointed at our property was, I'm forgetting the magic words, but extreme and outrageous.
Outrageous,
Yes,
yeah, right.
and caused our clients distress.
Okay, thank you.
Thank you, Your Honors.
Good morning, Michael Weiss from Howard and Howard appearing on behalf of John and Susan Leonowitz. This is an elderly couple who has a security system. That's it. To answer the few questions before I go into what I initially wanted to say, this is not about being on a lake. It's not just that they can see from the lake. Every neighbor can see the property, period. There is no expectation of privacy when everybody can see, period. End of story. We cited you to 2 cases in our brief where inside a dressing room, there wasn't an expectation of privacy. And we cited you to a case where an officer shining a flashlight inside a house was no expectation of privacy. Second, there is no ability to see in their house. They deposed the expert. We have the expert's report. The cameras do not look inside their house, period. They had in the other case 7 hours of uninterrupted access to the DVR system. They gave you the videos. There's not a single picture, still or otherwise, or single video showing inside the house. Why? Because the camera doesn't look inside the house.
Right.
It's not.
Ask you a question now.
Sure.
How much video existed at the time? And how much were they able to download in those 7 hours?
They downloaded everything. At least they said they did. Until they said, well, we couldn't find what we wanted to find, so therefore we must have missed it. So
So it's your contention that everything that was kept in your client's camera system save was downloaded by the.
I don't know what their expert did because I wasn't there but he was given the time to do it and he had the right to do it. So, and by the way, it's like any other surveillance system. It's a continuous loop. So nothing stays on the system. Once the system continues to be, something's recorded, it then records over it as long as nobody stops it from recording over it. So there's no set thing, but they had the right in 7 hours to look at anything they wanted. And they had the right to copy everything. And the fact that after 7 hours, and they told the court in the prior case, I'm reading what they told the court. The parties have exchanged discovery. Videos and images were taken from defendants' DVR, and defendants have already had time to discover if they would have done this in the prior case. So they said they had everything that they needed.
Okay, so you're stressing 7 hours and then there's testimony from the camera installer saying that backing up the entire digital recording system would take days.
He never said that until now. And more importantly, in this current case, if you look at exhibit number 2, that's their brief to the trial court in response to our motion to dismiss. There was not a single argument anywhere in there or in their counter motion for summary disposition, which was also filed. In either one of those briefs, there's not a single argument saying they need discovery. There's not a single argument saying that they need more time. There's not a single argument anywhere. That's called waiver. If you would have had an issue, because you previously said we have everything that we need, we can go to trial tomorrow. They have everything, we have everything. And then they dismissed the case without prejudice and restarted. And the court said, you're not doing this again. You've already done it. And there's nothing in the argument before Judge Grant on this case. There's no motion to compel. There's no request in either brief for more discovery or any discovery or saying it's premature. And now they're coming here and telling you it's premature, but they never argued it before. That's a waiver. And the fact is, if you can't find it in 7 hours, and by the way, there's not that many videos, but you can't find it in 7 hours, it doesn't exist. And the reason it doesn't exist is, as the expert said, the camera does not have the ability to look in your house. So you can keep looking forever. You could have spent 30 years, but there is nothing showing inside the house. And they have thousands of videos. And if it would show in the house, they would be there. Why aren't they there? Because as the expert said, I do this for a living. I've done this for all people throughout the state of Michigan, and I would never, ever, ever, ever have a camera looking inside someone's house. The camera simply doesn't do that. So you can say that it must be there, but that you haven't found it in 7 hours and you didn't argue to the trial court that you need more time, that you need something else, shows that that argument has been waived. In addition, this argument is totally dismissed on statute of limitations, and that was also briefed below. The trial court didn't address it, but we have 2 cases that we cited you to, which says there is no continuing wrong doctrine on an invasion of privacy. In their reply brief, they say, well, there is on trespass. That's great, but there's no trespass claim in this case. There's an invasion of privacy. And this court has ruled on a number of occasions, all cited in our brief, none refuted, all saying there is no continuing wrong doctrine. These cameras were installed in 2012. The plaintiffs moved in 2015. This lawsuit was filed in 2024.
Yeah, I mean, I think the Fraser versus Haney case from the Michigan Supreme Court kind of addresses that issue. I don't know if that's something you're familiar with and want to address, but it seems to me that case basically said, look, if the issue is ongoing, then it's true you can't get damages back more than 3 years behind you. But if the issue is ongoing, there's not a statute of limitations.
But it's focusing on trespass, and it's not for an invasion of privacy was already set. There's no continuing wrong for that. And they could have said that. If they wanted it to extend beyond the trespass decision, they could have said that, but they didn't. They limited it to trespass and didn't say it extends to anything else. But still, first of all,
Why wouldn't we just use the
I'm not the
general?
Court of Appeals, but when the Court of,
Well, hold on, let me just get my question.
I apologize.
That's all right. Why wouldn't we use the same principle that the Michigan Supreme Court used in Fraser versus Haney to say that because the alleged harm is ongoing, there's not a statute of limitations bar?
I'm not saying you couldn't do that. I'm saying if the court wanted that to happen, they could have said so too. So could you extend it? You're the Court of Appeals. You can extend what you choose to extend. And I'm not going to criticize you for extending something, except the fact that they had the chance to do so. They had case law there saying for invasion of privacy, it does not extend, and they didn't extend it. So if they chose not to extend it, I'm not sure it'd be appropriate for you to do so, but they haven't asked you in this case to extend it. They just tell you trespass is extended. Well, that's great. That's not a trespass case. Going back to what I was initially planning on talking about, a couple quick things. First of all, in order to be invasion of privacy, there must be a secret and private place. There is nothing secret and private about a backyard. Nothing. It is visible by everybody, all the neighbors, not just because you're on a lake, because you have neighbors. And there's no fence. It's our privacy fence. There's nothing blocking it. Second, what did they say that we saw? A kid in a bathing suit? Really, that is secret and private? People swim on lakes. People swim in pools. People go wear bathing suits all over the place. If a fitting room is not private, if the inside of a house with the flashlight's not private, the backyard with the bathing suit that anybody can see who walks by, and anybody on the lake, and anybody living on the lake, including the neighbors, is not private.
How would you distinguish this situation from you go into a locker room at the YMCA or a gym that has general public access, and someone's walking around the locker room with a cell phone taking a video? Would that person also not have a cause of action?
Yeah, I don't know the answer to that question to be certain. That's a totally different situation. That is, I don't think you have a right of privacy when anybody can see what you're doing. If they're then taking it into a bathroom and beyond something that's locked, that's a different story. And you shouldn't be, I don't think you can record inside. You don't have the right to record inside, but the Michigan Court Supreme, the law is crystal clear that you're allowed surveillance systems. And that's what this is. And a surveillance system is an exemption from the privacy. It says you're allowed to do it.
Is this a private lake though? I mean, the public can't just go on this lake, right?
I believe the public can, but everybody who's on the lake can see it. You see the picture, the neighbors. It's not private if everybody can see it. And again, what is private about a kid in a bathing suit? There's nothing. They showed the pictures of the kids running between the house. That's not private. Anybody from the street can see it. It's not And I think the lakes in,
Can the lake be seen from the street?
yes, if you look, you can't see the entire lake, but you can see part of the lake from the street.
How about the backyard?
You can see part of the backyard,
Not part of
including
it.
where the kids are running back, but from your backyard, the neighbors can see it. And again, this isn't something that's being done to survey them. It's to protect the people that are entitled to a security system. You're allowed a security system. By definition, a security system that focuses on movement is going to see what people are doing, period. They don't access it. They don't even know how to access it. Anytime they've accessed it, they've had an expert come in and try to take stuff off in order to do so. They're 80 and 79 and in the late 70s. They don't. It's just to protect them. And you're allowed to do that. And the rule's
Their
clear.
ability to access the images and the recordings have to do with the legal issue.
The legal issue says under 750.539D, this section does not prohibit security monitoring in a residence when conducting, unless it's looking at lewd and lascivious behavior. There's nothing lewd and lascivious about kids being in a bathing suit. And by the way, if there was, they should be ticketed for having people do lewd and lascivious things on their property that people can see. There is nothing private about the backyard, period. You can see it from any neighbor, and we showed you everybody on the lake, anybody driving by. It's not private. They wanted it private, put up a fence blocking their lake, put something up, have a separate area where the kids can be. They don't do that. It is not an invasion of privacy. It has to be a private area. Whether a locker room is private or not, I'm sure there's cases on that. That's not this case. They have said that there is no privacy when everybody can see it and people can see it. And that's what the court said. And there's no contrary cases. They try to cite you to cases outside of Michigan. Last I checked, we're in Michigan, and the Michigan cases say that it's not private. There is no intentional infliction of emotional distress. There's nothing so outrageous as to be beyond all bounds of public.
Question.
Sure.
Technology is changing. And as technology changes, what can be observed by the human eye now, people are able to observe much more detail. And how does that affect a person's privacy rights? I understand being on a lake, people can come up, past your backyard and look with their naked eye and see certain things. But how does the advancement of technology change people's privacy concerns?
I don't think it does, but if you have a privacy concern that you think because you're on a lake and you don't want everybody on the lake, including your neighbor who doesn't have to be on the lake, they can be on their dock, they can be using their own backyard, can see what's going on in the backyard without anything difficult. Because of the advancement of technology, if you want your backyard to be private, you put up a privacy fence around the entire backyard. You can do that. They didn't. They don't want it to be. Anybody can see. The neighbor just who walks outside their house can look and see it. There's not a single fence. There's nothing other than grass between the two houses. Nothing. Yes, there's a privacy fence on our side, but we're on our dock. Our dock is the water. We can see everything. There's no privacy fence. You can see everything up there, naked eye. And again, what are they saying that we looked at that's lewd and lascivious? A kid in a bathing suit. I mean, this is what we're talking about. This is why Judge Grant instantly dismissed it, because there isn't anything. They've had discovery. If you can't find in 7 hours of unrestricted access to something showing inside the house, the reason you can't find it, it's not there. And if you wanted discovery, the rules are clear. You must preserve the issue. And if you look at their motion for summary disposition, they said this case is ripe. And if you look at our motion, same thing. And there is no argument in either brief on this case where they said they needed more discovery. And in the prior case, they expressly stated the parties had exchanged information and it's ready to go to trial. So if it's ready to go to trial, you don't need more discovery. It's ready for trial. That's what they said. And now they're coming up here without ever arguing in this case that they needed more discovery, and they're telling you on appeal that they need it. So now they're going to come back and say, oh, well, since it's a continuous loop, and since we didn't record everything, it must be missing. It's impossible to stop the continuous loop. That's how it works. Our surveillance system, watch any TV cop show, where our surveillance system only goes for a week and then it just copies over it. That's what they do. So we're here trying to figure out now, you look at it, when the cameras are not focused in the house, the camera doesn't suddenly move and say, ha, they're in their bedroom. Let's move the camera does not look in their house. It just doesn't. That's what the expert said. And that's why they couldn't find it. This case is over. It was over the first time when they said that the discovery was done, and the second time because you didn't argue it. So even if you argue, and if you argued it, maybe you would have preserved it, but they didn't preserve that issue. And there's nothing to find about inside the house, and the backyard is not private. If inside a dressing room is not private, if looking with the camera in a window is not private, then looking in a backyard that everybody can see simply isn't private. And even if the language changes, the law is the same. You still must show it's a secret and private area. There's nothing secret and private about a backyard that's open to anyone who wants to walk by. If anybody wants to walk by and walk to on the neighbor's property, maybe they're pressed.
I hear you. I'm beginning to hear the same things.
Now sit
Is there
down.
anything else you want to address that you haven't already?
I don't believe so, but if you give me 10 seconds, I will confirm that.
Okay.
One more thing, that one of the elements of invasion of privacy is the right to keep that information private. They don't give you any information that they have a right to keep what everybody can see in the backyard private. It's different than the secret and private in the first place, but you have to have a right to do so. And if you exercise the right by installing a privacy fence or blocking everything in, or doing a separate area where the kids can play without anybody seeing them, they could have done that. They chose not to. Unless anybody has any questions, I'll take your advice and stop talking.
One
Oh, yeah,
question.
please.
You stated that your clients put the privacy fence up that's between their properties?
Yeah, that's been up there since sometime in the early 2000s.
Okay, but it was your client that put it up?
It's our fence, yes.
Thank you. That was my question.
But there's no fence on the other side. So again, all the neighbors on that
I
side
understand.
and on ours, we can still see on our dock because everybody has a dock. When you live on a lake, you walk on the dock, the privacy fence doesn't affect it.
Rebuttal?
Mostly, I want to try to address a couple of the questions that your honors had for Mr. Weiss. Judge Bazzi, you asked about how many recordings were there and what happened. Mr. St. Peter provided an affidavit that's in our appendix that discusses that. And my recollection is that Mr. St. Peter said there were hundreds of thousands of videos on there recorded when he was there in September of 2023 that reflected a period from late May 2023 through the date that he was there. And he was able to access a few thousand of them. They're a few seconds long each clip. But there were many more that he just didn't have time to recover, I guess you could say. And Judge Young's question was on point in that Mr. Pickard, if I'm pronouncing his name correctly, the defendant's consultant, said it would take days to do this. We didn't get days. Judge Cropton, you asked if the lake is a public lake. In fact, it is a private lake. There is no public access to. On the discovery issue, I can tell you most certainly when the 2022 case was dismissed, we had a motion pending, a motion to show cause because the defendants didn't do what in that case Judge Grant had told them to do. So, and that's why we argued in this case, Judge Grant, you've whipsawed us. You've said the discovery, don't worry about it because that issue is going away. In this case, you lose because you don't have the discovery. So the record will speak for itself about the arguments that were made in the trial court. But that I can tell you, like I said, most certainly that is something that was argued. And the motion was pending at the time that case went away. Unless your honors have other questions for me, I'll leave it there.
Okay, thank you very much. That case will be submitted. Moving on to item number 7, docket number 369819, Auto Owners Insurance Company versus J&T Towing. We have oral argument endorsed on both sides.
Good morning. May it please the court, Thomas Stidham, appearing on behalf of the appellant J&T Towing, and I would ask to reserve 5 minutes for rebuttal if necessary.
Yeah, we'll ask you to keep your own time, but that's fine.
Sure. Thank you. Your honors, I just want to highlight three. I think it was adequately brief from the appellant side, but I do want to highlight three critical ways in which the circuit court erred. And the first was the circuit court erred in misapplying and misconstruing or misinterpreting the law, specifically with respect to whether or not a petition was violated by being filed untimely. And specifically what I'm referencing is the specific provision is MCL 257-252A6, which requires any petition challenging either the reasonableness of the attorney's fees or the propriety of the removal to be filed within 20 days. And what we've said in our brief is really rings true here, because there is nothing about this or nothing about that section which was in any way ambiguous. There was nothing in the statute itself or any of the legislative history that we could find that would suggest that that specific term of the filing requirement is permissive. Instead, it's mandatory. And we cited in our brief this court's opinion in Knoll v. Ritzer. And the reason we cited that is really the reasoning in Knoll is directly applicable here by analogy, because in Knoll they were this court was determining whether or not another term of the abandoned vehicle statutory scheme, specifically the obligation to post a bond, was a mandatory term. The court determined that it was a mandatory term. And without complying with that term, the petitioner was entirely prevented from having a hearing. And we submit to this court that this court ought to adopt that same reasoning with respect to the specific gatehouse or gateway term of MCL 257-252A6, which is simply requires that a petition be filed timely within 20 days of the date of the notice. The notice is the Secretary of State form. That's a TR 52L form. In this case, it was I believe it was dated January 4th of 2021, and the auto owners, the appellee, filed its petition on February 9th, 2021, which is 16 days too late. The circuit court erred by simply misapplying the law. It didn't even acknowledge or address this argument in its opinion. It did not even address or acknowledge the appellant J&T's argument on appeal with respect to whether or not the petitioner could even maintain its petition or have a hearing when it failed to timely file a cause of action or a petition under this section A6 of the statute. Moreover, the trial court also erred here because it simply concluded in its opinion that the petitioner had, or I'm sorry, that the non-party, if you will, the Van Buren Township Police Department had failed to meet its burden in this case. And that was error because the clear import of what occurred at the underlying trial was this was simply a determination about whether or not the fee was reasonable. The auto owners checked on the petition itself that they were only seeking the reasonableness of the fees. Their brief in the trial court only addressed whether or not the fees were reasonable. They said the propriety of the removal, which includes the reporting and processing of an abandoned vehicle by the police department and from J&T's perspective. And they never even requested relief against the Van Buren Township Police Department in their brief.
Well, when we say, the term reasonable, I mean, I guess a very narrow interpretation of that is just is the per day amount a reasonable amount? I think a broader interpretation is the fact that you kept the car for that long itself reasonable, because that, of course, it's really how long you kept the car that caused the total amount to be, caused the total amount to be so high.
Right, but that wasn't, J&T didn't keep the car. We were just the custodian. The actual person that determines, or the entity that determines that, is law enforcement agency. And here, the law enforcement agency wasn't even made a party or asked, the auto owners did not ask or request the court to even assess whether or not they had done anything wrong in reporting, and that's where the reporting comes.
So you're supposed to serve the police agency with the petition. Presumably, if part of your argument is the police agency, kept the hold on too long.
Well, that's the argument of auto owners. Our view that auto owners had a duty and caused their own issue, and they never even produced or subpoenaed the police to be here, or to be in the trial court, which they certainly could have done. They had a duty themselves to go out and contact the police department, not just call the towing agency, but call the police department. And the reason was because the police department is the only entity as a law enforcement agency that can release the hold. And our duty as a towing agency to release a vehicle flows from the higher duty of the law enforcement agency. Once they tell the towing agency to release the hold, then they enter the vehicle in the abandoned vehicle process. And it's our obligation then to release the hold. And that's what occurred here. So it's not just the reasonableness of the daily storage rate, which was set by contract, but it's also the reasonableness of and that's what the trial court heard, of the plaintiff or the petitioner's auto owner's own actions in failing to follow up and determine the status of the vehicle. They simply supplied some notes, which were hearsay documents. The court nevertheless considered them. And but there was nothing to refute the unrefuted testimony of the underlying witnesses at the trial. So lastly, I would just note that the circuit court also erred in deeming that the burden had not been met by the Van Buren Township Police Department when they didn't appear. They were given notice. I don't know why they didn't appear, but again, if they had wanted to, if the petitioner auto owners had wanted Van Buren to put Van Buren's actions under the microscope, it had an obligation to request that at the court at the time that they filed their petition. But again, from the perspective of J&T, in this case, auto owners doesn't even get to that situation because their petition was simply late, untimely, and violated the statute, and the court ought not to have considered it. So unless there's any questions, I will. Thank you.
Okay, thank you.
David Kinzer on behalf of petitioner appellee auto owners. I entered this case late for the purposes of oral argument, and it is a complicated case. I haven't dealt with an appeal before, but had 6 different questions presented. I want to try to offer you a simpler distillation of the case as I understand it. I know it's about a relatively small amount of money for a towing fee and a storage fee. It's a lot, $12,300. But in terms of Court of Appeals cases, kind of small, about an insurance company. But I think there's a real injustice at the heart of it that the circuit court rightly recognized. We have a vehicle, it's impounded 480 days for seemingly no reason. a hypothetical investigation that never even occurred. And then after 480 days, while the vehicle is still on police hold, the police mark it as abandoned, which is something that's only supposed to happen at least 20 days after the vehicle has been released and waiting to be picked up. In effect, the police were appropriating the subject vehicle because auto owners failed to do something that the police were not letting them do. And now respondent is attempting to use that invalid abandonment as the reason to say that this fee cannot be challenged. And should that argument succeed, they will have emptied the towing laws of every statutory purpose. So
Why, if you're right that the abandonment notice or designation was too early, or was not made appropriately, why does that change the 20-day period that the petitioner would have to file the petition?
Oh,
Because I think, right, we're dealing with this 20-day situation, and the petition was not filed within 20 days. And I'm not quite understanding why, if there was an irregularity before that, it changes the 20-day requirement.
well, to set off the that 20-day requirement, you need a valid notice of abandonment, and the abandonment itself wasn't valid, and the notice also was invalid. So let me talk about how this is supposed to work, right, and what didn't happen. So first, we have 252 D1K that allows the police to tow a vehicle after an accident when it can't be driven. And the police can then hold that vehicle for a criminal investigation. And the owner should be notified when that investigation is over and the car is released. Once it's resolved, the owner should be notified of the release. That's 252 D6. That requires a 20 to 30 day redemption period when the owner can pick up the car. If they do not redeem the vehicle within 20 to 30 days, the towing company should notify the police that the vehicle has been abandoned, and the police may then enter it as abandoned in their law enforcement information network. That notifies the Secretary of State, which sends to the owner notice that the vehicle has been abandoned. And the requirements of this notification of abandonment are under 252A13. It requires the basic information like the year, make, model of the car, also the current place where the vehicle is, the procedure to redeem the vehicle, warning that failure to redeem the vehicle in 20 days may result in sale of the vehicle, the procedure to contest the fact that the vehicle is considered abandoned or the fees were unreasonable, and the petition itself to request that hearing. The owner then has the 20 days to redeem the vehicle before it can be auctioned. In addition, the owner has 20 days from that valid notice of abandonment to file their petition to contest the fees. And that's what's supposed to happen. That's the procedure that is required by the statutes. It's not what happened here. We have the insured, Ms. Elizabeth Guy, involved in a serious car accident on September 16th, 2019. One of her relatives pays a fee, gets a release form from the police the next day, but she goes to the towing company, doesn't realize that the vehicle isn't drivable, so she leaves to go figure that out. Ms. Guy's health worsens. She passes away on September 22nd, and now it's auto owners that's trying to get the vehicle. It comes to J&T the next day, September 23rd. They're told they can't, would not release. Auto owners checks again in 2 days, still told not cleared by the police. Again on October 2nd, again the next day, the day after that, October 7th, October 10th, 14th, 16th, 18th, 21st, 25th, and 28th, so on. They wait a week, sometimes they wait a day, but nothing for 480 days. The police did not appear at that 2021 hearing, even though they received notice of it. So they couldn't say why the vehicle was impounded that long. But we know from the testimony of J&T's owners that no one from the police ever came to look at the vehicle. It just stayed on the lot untouched from September 16th, 2019 to the beginning of 2020 to the end of 2020 until January 4th, 2021, when the Van Buren Township Police entered it into their system as abandoned. And the law says that what has to happen is the police release the vehicle, and then not less than 20 days, the towing company notifies the police that the vehicle has been abandoned. And that didn't happen. The police just decided one day that 14 months was fair enough, was long enough, so fair enough. Now it's abandoned.
On the petition form,
Right.
there's, and I don't know if you have it handy, but I'm sure you're familiar with what it looks like. Question number 1 on the petition has 2 checkboxes. First checkbox is whether, so it says the petitioner requests a court hearing to determine, and then checkbox number A, letter A, is whether a vehicle owned by the petitioner was properly deemed abandoned or removed according to law. That checkbox is not checked in this particular petition. And then letter B is the reasonableness of the towing and storage fees. That's the checkbox that's checked. So in some ways, I know a checkbox is a lot to quibble over, but in some ways, a lot of what you're arguing would have been better presented under checkbox A as opposed to checkbox B, it seems to me.
So there's two parts to answer that. And the first part is that what the towing company is arguing is essentially a jurisdictional argument, as I understand it, that the court did not have jurisdiction to make a finding of fact about the reasonableness of the police actions. That what you what the court can do is limited to what's checked on the box on that form. And there's nothing in the law that says that. If you go to 252.
Well, I get what you're saying, and I don't know if jurisdiction is the right word for it, but it seems like the issue is if you're gonna say that 20 days the 20-day deadline doesn't apply because they designated the vehicle abandoned in an improper way, it seems to me you'd have to check the first checkbox to talk about that. And that once you just check box the one about the reasonableness of the towing and storage fees, it's hard for you to now be arguing, oh, well, the 20-day deadline didn't apply to us because they didn't properly designate the vehicle as abandoned. That's kind of how I'm thinking of it.
So we have to remember this isn't a trial. Also, it's a hearing that comes under the statute. There's no discovery period. We didn't receive the brief from J&T Towing until the day before the hearing itself. So we had no idea at that point that J&T Towing was going to be saying it's the police's fault, not ours. Because remember, you go by the statute, and what it says is that J&T Towing, the towing company, has to be the entity that declares it abandoned. So if we didn't have word that the vehicle was released, if there was a problem with the abandonment, if we were contesting the abandonment, it wouldn't it's supposed to be the towing company that is responsible for that. So the towing company should have been able to. The circuit court found that the towing company was certainly aware by virtue of our briefs that was going to be central to our argument, and they should have been able to respond to that. And they could certainly be expected to be familiar with the statutes that they are collecting the fees under to know that they are the party that is responsible for deeming it reasonable, and should have been able to answer that. As you said earlier, the reasonableness of the fees, to read that so limited that it's just about is $35 a day or $25 a day, is that reasonable? You know, there's nothing in the statute that says that is how limited it is. And certainly when J&T Towing received our brief, they would realize that that was not our argument. It's never been our argument. And
At the time the form was filled out that Judge Gorobkin just addressed, it was your understanding that this, or it was your belief that this was timely filed, so that you need not check the first checkbox. You're only going in there to argue about the dollar amount that's due. Is that correct or not?
So we get this letter in the mail. It's not said, it's not even called notice of abandonment. It's called a bill of sale. And it does not have the procedure to redeem the vehicle. It does not have the petition to contest the fees. It does not warn that the vehicle may be sold if it is not redeemed in 20 days. All those things are required by the statute.
But it does have the date of notice on it as the date.
The date of?
It's stamped, or it's typed 01/04/2021. So that's the date that the notice was issued.
Right.
And there's a box up above there that says you have 20, basically you have 20 days from this date to file a petition. So that part you knew about.
But we did not know that it was actually acting as a notice of abandonment, that it was saying that it was a bill of sale, when clearly it was not a bill of sale. We still redeemed the vehicle on January 7th, shortly afterward. And, you know, all these things, like including the petition, that clearly matters. If you don't include the petition, it takes much longer to file your claim. The redemption period, too, that is mandatory and required by the statute. And if the court were to say that auto owners' challenge was nonetheless untimely, all those procedures would be rendered meaningless. There would be no way to challenge the fact that the towing company ignored, and the owners testified that they always ignored the 20 to 30 day redemption period. And there would be no way to enforce the statute's notice requirement. Why would police ever bother, or police and towing companies and the Secretary of State ever bother providing a 20 to 30 day redemption period or sufficient notice if they could provide insufficient notice and it would still count? Like, those are due process rights set out in the statute. And it was come by the legislature in a very comprehensive scheme to balance the needs of the police, the needs of traffic, with the rights of vehicle owners. That's what the statute is trying to do. And if we just buy that all of those requirements don't matter in this case, all those process rights would be illusory. I will rely on my briefs if there's not any further questions.
I don't have anything.
Thank you very much.
Thank you.
Just respond briefly. First of all, I just want to address a couple things that were raised in by counsel in argument. First, there was an investigation, obviously, but because there was no police testimony, or the petitioner never sought testimony from the police department with respect to the accidents or the accident at issue. We don't know the status, bless you, of anything that occurred with respect to the decedent or even those cases or the investigation. In other words, we don't know whether or not it was a wrongful death accident or simply some kind of traffic matter, or was it placed on hold for criminal charges related to a defendant that wasn't incorporated or wasn't even referenced by the auto owners. We just don't know that because they didn't do that discovery. Second of all, as I stated, or as J&T stated in its reply brief, I believe that auto owners is conflating a couple of the statutory concepts that are contained in the statute. And I'm going to get a little geeky, but it's very simple. There is a difference that our legislature put forth in MCL 257-252D, and 1K is where there's an accident involved. But if one looks at section 3, in section 3B, it says, and I'm just going to read this real briefly, enter the vehicle. This is the duty of the law enforcement agency upon an accident. They have to first check and make sure it's stolen, which is subsection A. And second is subsection B, is enter the vehicle into the law enforcement network, information network, as an impounded vehicle within 24 hours after ordering to impounded the vehicle. So I just wanted to highlight, because there seems to be some confusion. They're not entering the vehicle as an abandoned vehicle. That only occurs after. And this whole releasing 20 to 30 days, council is conflating that. It's only after, in the statute, that after an impounded vehicle is released by the law enforcement agency, then what the statute says is they have to enter it. The law enforcement agency, not the towing company, has to enter the vehicle into the lien system as an abandoned vehicle, and then it's processed as a abandoned vehicle, and the law enforcement agency has to follow the procedures set forth in section 252A, and that is section 252A is what gives the owner and the secured parties notice and the ability under MCL 257-252A6 to contest and file the petition and contest either way.
But it does seem like that happened a little early. Am I missing something? That the car wasn't released.
It was not released
until a certain date, and then they didn't wait 20 days after the car was released to identify the vehicle as abandoned.
No, but what happened is, again, from J&T's perspective, what happened here is very simple. There was an accident. The police impounded the vehicle. As counsel said, a family member came, obtained a release to get their personal items the next day. When they saw it wasn't drivable, they were waiting for their insurance company. A few days later, on September 22nd, then the owner of the vehicle passed away. And at that point, that night is when the officer from the Van Buren Township Police Department called J&T, ordered a hold on the vehicle for investigation. So at that point, J&T has no authority to do anything.
Yeah, I know that, but that's like a year, more than a year before the events.
Right.
Here. The events here are somehow this vehicle got designated as abandoned.
Yes.
A notice of that abandonment went out. And then 20 days later, no one filed a petition.
No, that's correct, Judge. But
the question is, I mean, your opposing counsel is saying, yeah, but the correct procedures were not followed to wait a certain amount of time before designating the vehicle as abandoned.
No,
help me understand why that.
In fact, I would submit, J&T would submit that it's best that it gets obviously notified and entered into the lien as abandoned as quickly as possible, because that kicks into action the notification purposes and allows litigants or vehicle owners and their secured parties. It starts the process. to get them notice as quick as possible so that they can redeem it. I understand that's auto owners' argument, but in here, what happened is once the hold was removed, and again, auto owners never determined why the hold was removed. They can't explain it because they never subpoenaed or asked the police department about that. Once the hold was removed, the police department determined that the hold was off for whatever reason, we don't know. And they went and entered it into abandon right away without waiting for us to notify them or anything. And so to start that process as quick as possible. And then the fact that auto owners failed to redeem it, or I'm sorry, they did redeem it, the vehicle within 3 days of
3
the
days,
notice.
right.
And then filed an untimely petition. But that doesn't, there is no flaw in the system. And in fact, the circuit court's reliance on the fact that Van Buren Township, that's the predicate or the basis for its, the primary basis for its opinion, is that Van Buren Township police didn't appear at the hearing and didn't carry their burden. But again, this was a reasonableness petition. Only J&T Towing had the burden, and we met that burden and obviously prevailed in the trial. So unless there's any other questions, I would ask that the court enter its order reversing the circuit court orders and dismissing the plaintiff's petition and entering judgment in favor of J&T. Thank you.
Thank you both. That case will be submitted. At this time, we're going to take a brief break and we will be back to pick up the 11 o'clock portion of the call. Thank you.
All right.
Okay, thank you for your patience. We are back on starting the 11 o'clock portion of the case call. And the next case to be called is item number 8, docket number 374135, Deshaun Davis versus Charter County of Wayne. Good afternoon.
Afternoon, Your Honors. May it please this court, Allegra Mason on behalf of appellant Wayne County. Your Honors, the trial court erred when it used the essence of governing standard to evaluate Wayne County's claim to governmental immunity in this case. The Governmental Tort Liability Act, the GTLA, gives us the definition of a governmental function, which is any activity that is expressly or impliedly authorized by law. The Jazz Festival, where this incident occurred, squarely falls within that definition of governmental function. None of the exceptions to the GTLA apply, and summary judgment should have been granted to Wayne County on the basis of immunity. And unless the court has any other questions, I'd rest on my briefs.
Don't have any.
Thank you.
Thank you very much.
Morning, James Tantalo for plaintiff. May it please the court. Wayne County's appeal here focuses on the trial court's reasoning, and we acknowledge that the court's analysis relied heavily on the Parker essence of governing standard. But that doesn't resolve the appeal. To reverse, Wayne County must show more than a defect in the trial court's reasoning. It must show that it was entitled to summary disposition and dismissing the case with prejudice, and it was not. Our complaint expressly invoked MCL 691-1406, alleging plaintiff was injured while seated under a county-owned, county-maintained, and county-assembled tent structure, and alleged that Wayne County failed to keep that structure in reasonable repair and safe for public use. Wayne County nevertheless sought dismissal with prejudice and argued any amendment would be futile. So our position here is narrow. Even if this court disagrees with the trial court's arguably Parker-based reasoning, Wayne County still did not establish entitlement to dismissal of the action as a matter of law. Wayne County's appellate theory is that the Jazz on the River Festival was a government function under the current GTLA definition and MCL 123.51, but its motion below did not ask only for clarification of the judicial function standard. It asked for summary disposition and dismissal with prejudice and argued amendment would be futile. So even if Wayne County identifies an error in trial court's reasoning, it doesn't automatically prove entitlement to terminate the case. Essentially, it is possible for amendment to allow continuance in this case, and so even based on the prior court's decision, wouldn't necessarily completely dismiss the case.
What would the amended complaint say that would survive? Well, let me back up. Isn't Jazz Fest a government function? Or is that something you want to plead?
No, we do agree that it is. What we're arguing is that the public building exception would actually apply here.
Because the tent is a public building?
Well,
I'm just trying to find out.
Yes.
What you're saying. Okay.
Arguably. Wayne County may eventually prevail on that, but it's still an amendment that we could potentially make.
Any other amendments that you would consider?
No, Judge.
Okay, I think that's it. Thank you very much. Any rebuttal?
Your Honors, plaintiff appellee failed to raise in its briefing any building defect exception arguments. This was addressed in the lower court by Wayne County's initial motion for summary disposition. In fact, Wayne County argued that the factual development on the record would not entitle plaintiff to claim the building exception. They did not argue otherwise in the lower court or in their briefing before this court. And since Michigan doesn't raise it or waive it, state we would ask that the court disregard those arguments. But regardless, the factual record developed in the lower court doesn't support a finding that the tent was in fact a building, and Wayne County would be entitled to summary disposition. With that, thank you, Your Honors.
Thank you very much. That case will be submitted. The next case is consolidated, two docket numbers. It's item number 9. Docket number 375-588 and 376-447. Both are called In re Dawson minors. And we have an appellee endorsed for oral argument. Anyone? Okay, so that case, those cases will be submitted on the briefs. Moving to our next item, it's item number 10, docket number 376-675. In re Harris, Rogers, and Williams minors. We do have one person for oral argument. Anyone check in? Okay. And no one checking in on that case as well, we will have that case submitted on the briefs. Moving on to the next item, it's item number 11, docket number 377023. In re M.A. Thomas minor, and we do have a student endorsed for oral argument. Welcome.
Good afternoon, Your Honors. My name is Natalie Blair on behalf of the appellant father, Deshaun Thomas. To put it simply, this case arose from an incident which involved some dangerous and erratic behavior of the mother of the child in this case. And instead of evaluating the actions and the fitness of the mother and the father separately, as required by the Michigan Supreme Court in Henry Sanders, the trial court imposed the dangerous behaviors and actions of the mother onto the father and adjudicated both parents as being unfit. And any evidence that was presented in the trial against Mr. Thomas, even when taken in the worst light, was not enough to meet the preponderance of the evidence standard that's required at the adjudication and jurisdiction trial. And while in our brief we could contesting both the removal and the adjudication, here I'm going to focus mainly on the adjudication stage, but all the removal arguments are in the brief. So as I briefly mentioned, the petition for removal and jurisdiction in this case was brought after an incident in which the mother, the father, and the child were in a car. The mother was driving. She saw a neighbor with whom she had previous animosity towards, and she pulled into a gas station, got out of the car, and threatened him. The neighbor says she has a gun. The CPS was unable to determine from the video footage whether she actually had a gun at this incident or not. But in this incident, Mr. Thomas, my client's involvement was so minimal that he was not even mentioned in the police report that resulted from this incident. Instead, he stayed with the child near the car during this incident and only intervened in the altercation between the mother and the neighbor as to act as sort of a peacemaker to break up, to make sure the altercation did not become physical. So he was acting in the best towards the safety of the child throughout that incident. And it's this incident which the trial court based most of its determination that he was unfit on. There were also previous incidents of domestic violence between these parents from the year prior. However, at that point, Mr. Thomas, there was no charges brought. Instead, they dropped the charges, and he completed a set of anger management classes, which CPS had testified that he completed successfully. And CPS had the opportunity at that point where it was maybe a more solid incident of domestic violence to intervene, but they did not at that point. And now at this point, they're bringing it up in regards to this, the gas station incident that I just described. And this is simply just that the state did not prove its evidentiary burden in terms of evidence against Mr. Thomas himself as being unfit in regards to this petition. As the Michigan Supreme Court said in Sanders, that due process requires a specific adjudication of a parent's unfitness before the state can infringe the constitutionally protected parent-child relationship. So we're really just arguing that the state didn't meet its burden, and instead of its burden for proving that Mr. Thomas himself was unfit to continue care of the child, and instead attributed the mother's untreated mental health, which contributed to her erratic and dangerous actions, onto Mr. Thomas, instead of evaluating each parent for their individual fitness. So for that reason, we request the court to reverse the taking jurisdiction and adjudication of the child in terms of Mr. Thomas. I'll take any questions or else.
I mean, I guess I'm trying to think through, you said that the incident in the car at the gas station was the main incident, and there are all sorts of problems with blaming Mr. Thomas for that situation. But there were several incidents before, I think before that, something involving a bottle that got thrown and hit the child on the head or something like that. And then there was also something in the snow, the child was dropped because of Mr. Thomas hitting the mother, something in those. And so I'm trying to piece together why, even if we remove the gas station incident, why those two other incidents, plus I think the mother basically testified that he had been abusive towards her, would not support the trial court's adjudication.
Yes, Your Honor. So the pop bottle incident that you mentioned happened in 2024. So a little over 6 months before CPS was involved again for the gas station incident. And in that case, it's Mr. Thomas's position that it was an accident. He threw the empty bottle and it hit the child on the head on accident. And that's the case where there initially may have been police charges, but the charges were dropped. Like his criminal record does not reflect any sort of domestic violence on that. And the mother even testified that she agreed to having those charges dropped against him. And he did complete anger management classes as his offer to having the charges dropped. And he successfully completed those. And so, and that was like the last major incident that was actually substantiated. The incident that you mentioned, or the allegation that you mentioned of the mother dropping the child in the snow after being allegedly hit by Mr. Thomas. CPS investigated that incident. There's no police reports of it. They couldn't really confirm whether or not this had happened. There's no, so that event was unsubstantiated, and they were actually in the process of closing out that investigation when this gas station incident had occurred. And there's also previous results or previous evidence of the mother's mental health being a challenge for her. She testified that she was not in treatment for her mental health and not taking her medication as prescribed by her primary care physician. There have been incidents where Mr. Thomas has called well checks on Miss Couch is her name, on the mother, just out of the fear for the safety of her and her child, as well as there is a mention of a police report where like they showed up to her house where she was like banging her head against the wall or just acting in an erratic behavior in the presence of the child. So in terms, we're really just arguing that the evidence presented does not really meet the preponderance of the evidence standard. Mr. Thomas testifies that there was no domestic violence, but even taken, so at that point with the mother's testimony, it's kind of a he said, she said, but that level of evidence presented does not reach the preponderance of the evidence standard, especially if you take into account that as we argue in our brief, the testimony of the CPS caseworker as well as the mother's doctor is inadmissible hearsay evidence. So it really would be just the word of Mr. Thomas against the word of the mother. And in this case, his behaviors do not really add up to meet the preponderance of the evidence standard to deem him unfit to care for the child.
And just to confirm, the dropping the baby situation, you said DHHS was in the process of closing that as unsubstantiated.
Yes, ma'am.
Whereas the bottle throw, your client disputes and no formal criminal charges were presented, but that wasn't found unsubstantiated by DHHS.
Correct. That was found substantiated at that time. And we wonder why if DHHS or the state had any concerns about Mr. Thomas at that point, why they didn't remove then, but they did not. They chose to let the child remain in the care of the parents at that point. But it's just now when there's more erratic behavior of the mother that's putting the child at danger, or that the court decided to remove and adjudicate both parents as unfit instead of adjudicating both parents for their own actions separately.
And it's your argument that the bottle incident standing alone does not meet the preponderance of the evidence standard?
Yes.
And then this is kind of a bigger picture, but under the In re Sanders framework, the solution here, if the trial court felt that, or if DHHS felt that the mother was unfit, is to keep custody with the father, but perhaps impose some sort of conditions so that the mother is not charged or left alone with the child, that kind of thing.
That's correct, yes. And to clarify, based on the DHHS's brief, we are not suggesting that there needs to be two separate trials for each parent, just that each parent's actions need to be considered on their own within the same trial.
Thank you very much.
Thank
Very
you,
well
Your
done.
Honors. Thank you.
That case will be submitted. The next case on the docket is item number 12, docket number 376786, in re P&N or minor. We do have one party endorsed for oral argument.
No one's checking.
Okay, with no one checking in, we will submit that case on the briefs. And the next case is item number 13, docket number 376904, in re D.L. Smith minor. And we do have endorsement for oral argument, and we have another law student with us. So welcome.
Good afternoon, Your Honors. May it please the court.
Carly Brookhuizen on behalf of respondent appellant father Tawan Smith. Today, we are asking this court to reverse and remand the trial court's termination of Mr. Smith's parental rights. We ask this on two main grounds. First, the trial court erred in terminating Mr. Smith's parental rights at initial disposition without first articulating a factual finding of aggravated circumstances. Second, the trial court erred in failing to make a meaningful best interest determination by not looking into the specific needs of DJ Smith. I'll begin initially with the first issue and then transition into the second. The legislator has laid out specific procedures for the trial courts to apply when terminating parental rights at initial disposition, which includes making a specific finding of aggravated circumstances. In Enright Simonetta, this court held that failing to articulate such specific findings of aggravated circumstances is grounds enough to vacate a termination of parental rights. Here, the trial court never stated that there were aggravated circumstances, never articulated any facts about it, and never acknowledged any standard of proof for finding it as such. Your Honors, the rule of law includes procedural law. Both this court and the legislature has raised making a specific finding of aggravated circumstances to the level of a procedural requirement. This requirement must be applied evenly, or the requirement becomes a procedural mess. Here, this would not be a harmless error because this would allow the court in remanding to not only make the articulated finding of aggravated circumstances, but also redo its clearly cursory best interest analysis that they failed to do in upholding this court's case law precedent. Which leads me to my second point. This trial court failed to make a meaningful best interest determination by not focusing on the specific and individualized needs of Mr. Smith's son, DJ. Once again, the legislator has laid out a two-part procedure for terminating parental rights. First, statutory grounds must be satisfied, and then even if statutory grounds have been satisfied, a best interest determination must be made in every single case. If the legislature simply wanted a trial court to be able to bypass the best interest determination, even in aggravated circumstances cases such as our own involving sexual abuse, they would have written the law as such. However, best interest determinations is a requirement for every single case, including aggravated circumstances. Here, the trial court attempted to bypass the statutory requirement as they heard little to no testimony about the child's needs or the child's relationship with his father. And the trial court did not discuss the child in question when making its best interest determination, effectively skipping this part of the statutory scheme and failing to follow the case law of this court and the Michigan Supreme Court that requires best interest determinations to focus on the specific needs of the child. The Michigan Supreme Court and NRA JMG holds that best interest analysis must consider whether retaining the child-parent relationship in some form is in the child's best interest. The trial court in our case did not address this at all and did not consider whether this relationship would be harmful in the severance of it or would be helpful to retain in any little case, in any shape or form. This court, in a case with similar facts to this one, has reversed determination of parental rights because there was no evidence demonstrating harm to the specific child in question. Here, we have a similar situation where DHHS failed to obtain any evidence that DJ was in specific harm from his father or that termination would be in DJ's best interest. There was no testimony from the child's therapist, no psychological evaluation on the repercussions of keeping or severing the child-parent relationship, or any expert testimony on harm that could befall to DJ. Simply, the court relied on Mr. Smith's misconduct to deem him as a deficient parent, and that was the only factor weighing in favor of termination, but that was the only proof that the court seemed to need to make such a best interest determination. Your Honors, we're arguing that such a cursory best interest analysis cannot be grounds for termination in a case such as this one. And I'll take any questions that y'all have.
I have a question with your first argument. So your first argument is that DHHS didn't make clear that it was presenting aggravated circumstances, not that the sexual abuse of a half sibling is not enough to be an aggravated circumstance, right?
Correct, Your Honor.
So there's a world in which if we were to agree, it goes back and they just say, oh, by the way, this is an aggravated circumstance and it fits under statute, and then that's that.
Yes, Your Honor, we argue that this reverse and remand would allow for both the redoing of the aggravated circumstances finding and the best interest finding. But correct, we are asking that this court uphold its own standards as well as the legislature's required procedure for finding specific aggravated circumstances. This is helpful to put respondents at notice. It can't just be simply applied in cases where aggravated circumstances do exist. Otherwise, trial courts will fail to make them in all circumstances as required.
I just ask what, I mean, what is it other than, I mean, I take it you're not saying, are you saying that the trial court has to use the words aggravated circumstances?
Yes, Your Honor, we're arguing that they have to use the words aggravated circumstances. We're arguing that they have to put the respondent on notice of what aggravated circumstances mean, including the raising this point to be terminated at initial disposition. And they must articulate the standard of proof for finding that, which must be clear and convincing evidence.
I mean, I think it's in the petition that the petition does say that the petitioner wanted termination at the first disposition.
Yes, correct.
And I think that the trial court made findings about the sexual abuse of a sibling.
Correct.
Use the word aggravated circumstances, but I think the findings were made.
The findings were made,
which I think is a little different from the case that you cited, where it wasn't even clear, do those facts really rise to the level of aggravated circumstances?
Correct, but this court has repeatedly stated over and over again in case law such as N. Ray Simonetta, N. Ray Glover, and most recently last month in N. Ray Berryman, that these specific articulated findings of aggravated circumstances must be done in every case involving them, or that alone is enough to vacate the termination.
And,
Go ahead.
okay. And then with respect to the best interests, is it fair to restate your argument as anticipatory neglect can't be like the single do-it-all factor?
I would say it goes a bit beyond that. I would say
Okay.
that's part of it, but I would argue that we are simply looking for the court to look towards the specific needs of the child. And here, the trial court did not mention DJ barely at all. There was little to no testimony given about any harm that would specifically befall to this specific child. And furthermore, the evidence that DHHS brought forth and the factors that the trial court considered simply focused on Mr. Smith and his misconduct and not at DJ at all. And I feel like that would be more of the core of our argument, is that the trial court must consider each child individually, as has been restated by this court again and again, such as in N. Ray Olive Metz and in N. Ray White. Thank you, Your Honors.
Thank you very much.
Thank you.
Very well done.
Thank you.
That case will be submitted. Moving on to the next item on the case call, it's item number 14, docket number 377240, in re Zervos minor. Do we have anyone checked in for them? Okay, that case will be submitted on the briefs. And then the final case is item number 16, docket number 378123, in re Stasker, Meekhoff, and Smith minors. No one is endorsed for oral argument, so that case will be submitted on the briefs. That concludes today's session of the case call, and thank you very much.